Hello and welcome to Media 7 in front of a live audience at Auckland's Classic Comedy Club. In this week's show we'll look at a rethink of court suppression orders and at the rise and fall of young sportsmen in the news media. But first, it's a Newsmash in a week when our best and brightest did not shine brightly. 100% pure New Zealand. The glories of the last great southern wilderness have been on display to the world. Yes, Associated Press syndicated this report on this year's Otago University Toga Party Parade, which spread sick shit and beer all over Dunedin's main street. And YouTube fairly fizzed with citizen video of the same sorry events.
Instead of things getting better, we're going downhill.
What these future pillars of society don't seem to realise is that in 10 years' time, when they're going for that cool and prestigious job, that video will still be on the internet. And yeah, Facebook keeps a copy of every picture you post too, forever. You've blown it, basically. But it's worse than that. Yes, this is a real headline in Britain's Daily Mail newspaper, which, it must be said, does a roaring trade in things that give you cancer. Just this year there's been wine, salty soups, obesity, taking HRT, taking something else instead of HRT, loneliness, dope, coffee, and doing cocaine if you're a dog. In happier news, the Mail also finds that shagging prevents cancer, as does walking, sunscreen made from coffee, just don't drink it. But you can drink tea, unless it's green. But it gets worse again. According to yet another Daily Mail story which coursed around the world, Facebook and all those other social networking sites are melting our children's brains.
Of an identity that needs to be bolstered up with Twitter and perhaps an increased recklessness.
The issue was taken up, after a fashion, by BBC Newsnight.
Where was I? Oh, yeah. Too much time spent on social networking sites makes your brain addled.
Which pitted sceptical hero Dr. Ben Bad Science Goldacre against Dr. Eric Sigman. He's the Facebook cancer guy.
You can make anything look dangerous if you're selective in which evidence you quote, and that's exactly what Dr. Sigman unfortunately does.
The paper was supposed to be a one-sided provocative feature article for the biologist to make people think more carefully about where society was going.
So it's open and shut, unless you look at all the evidence that says it isn't. Frankly, we'd love to stay with this, but it's like an hour since I updated my Twitter stream. And that was your Newsmash. Now, the ability of the courts to suppress the reporting of names and evidence provides a flashpoint between various ideas we hold dear in a democracy, including freedom of speech and the right to a fair trial. Hence the almost daily dance between reporters, lawyers and judges over what's fit to print. Since the mid-90s, the rest of us have come into the picture as the internet has opened the way for us to report to each other. Is the practice of suppression orders due for a change? And if so, what change? That's the question posed by a new issues paper from the Law Commission. It's also the focus of a private talking shop being staged by the police in Auckland this week. Joining us to talk about what we need to know are the Law Commission's Deputy President and the author of the paper, Warren Young, and his Law Commission colleague Val Sim, and representing the journalists, Bevan Rapson, editor of Metro magazine. Welcome to you all. Warren, what's prompted this review of suppression orders? Has there been a perception that something needs fixing?
Certainly there's a perception that suppression orders are not working really as well as they might at the moment. Apart from anything else, there's a lot of inconsistency in practice around the country, some lack of clarity about what the rules are. The real impetus for our work is that we're undertaking a much larger project with the Ministry of Justice on simplifying criminal procedure. And as part of that project, we really thought that this was an issue that needed to be looked at to see whether the rules could be improved.
And one of the issues specifically identified in the paper is that the understanding, particularly by journalists, of exactly what is called for under a suppression order is often not clear. Why is that?
It's often not clear because there is no standard form for a suppression order. Sometimes, not always, but sometimes judges are not entirely clear about the scope of the suppression order that they're making. And sometimes too, it's not easy for journalists after the event to find out what it was that the judge actually said. And so we actually think there's some room for clarifying that as well, so that when suppression orders are made, it's actually clear what was done.
Now, as I read the paper, it starts out from a fairly clear philosophical stance that open justice is your starting point, and then you're going to look for reasons to make exception to that. Is that a good understanding?
Oh, absolutely. We think it's imperative in a democratic society that the starting point is open justice. The starting point is the public has a right to know what's going on in courts. And indeed, it would be a sad day for the country if that were not the case. So the real issue is in what circumstance does that starting point of a presumption of open justice need to be overridden for some reason. And certainly we would take the view that the circumstances in which that's justified are pretty limited. The real issue is how limited.
Val, you come from a human rights background. I presume that something about that touches on this issue as well.
Yes, it does. Generally, the case law starts from the proposition of open justice rather than freedom of expression, although a number of cases also refer to the right to freedom of expression under Section 14 of the New Zealand Bill of Rights Act. The exact scope of that right isn't clear. It hasn't been clarified by the courts as yet. But whether or not suppression falls within that freedom of expression right or not, in practical terms the result is the same. It's the starting point you referred to before of you must have a good reason to depart from open justice or a good reason to suppress information.
Bevan, as a journalist, you've reported on court cases. Have you always felt that you've gotten your fair serving of open justice, or have you been frustrated at times?
Frustrated at times. I think all media who have covered court cases know that there's a lot of frustration around this area because there seems to be no strict form of the way things happen. It varies from judge to judge, and often it's hard to find out exactly what the status of any particular suppression order is. The lawyers will make the most of that to confuse and bamboozle where they possibly can.
This is the cliche, isn't it? Is the lawyer and the reporter duelling every time there's an opportunity for suppression. You know, it's you against the defence lawyer. Is that how it actually works?
And sometimes I think lawyers throw it as a little bone to their clients anyway to get an interim suppression, and it's going to be overturned. But you know, before a JP on the weekend or something like that, and the client says, "Oh my God, is my name going to be made public?" That hadn't occurred to me.
So it's often likely to be a JP rather than a more experienced judge who might not have it on.
They're the worst, I think. But gee, we've had plenty of examples of judges who have brought down suppression orders which they just don't seem to have taken into account the idea of open justice right from the word go. It's you know, there's notable cases going back, say to when the Herald had to go to court over the billionaire dope smoker or dope importer. Took them 8 months to finally get you know, that case brought to that name.
And as a result of that, we can actually say his name. It was Peter Lewis. Yeah. He was the millionaire dope smuggler.
Say it loud and often.
Indeed. Was that unsatisfactory that it took 8 months for the Herald to actually win its case and actually be able to report that man's name?
Oh, I think that case certainly was unsatisfactory, but I think there's a more general issue that we need to take into account here, which is really the way the courts on a day-to-day basis operate. In defence of courts and judges, they're often confronted with very long lists, very large numbers of defendants. The police have no interest in opposing an application for suppression. So it's not a contest between two parties, it's simply an application from one side. There isn't sufficient time for the judge to deal with it properly if the judge is confronted with, as is often the case, 70 to 100 offenders to deal with in one day.
A lack of time and resources seems to be the root of many ills in our system, doesn't it?
Well, I think it's the lack of time and resources, and certainly that is one of the ills in the system, and it's one of the things that our project with the ministry is trying to address, which is inefficiency and delay in the system. But I think it's also to do with the fact that when there are no clear lines, when judges have very wide discretion, and really the law is not clear about the scope of that discretion, when you're confronted with a busy court, lots and lots of defendants, you actually take the path of least resistance.
Now, if we could go back to the Peter Lewis case, which I think is interesting because it was the first clear example of what you've described in the paper as the futility argument. In the internet age, everyone is going to know these things anyway. It can be reported in overseas publications, so why bother? You gave that fairly short shrift in the paper.
Yes, I don't really buy the futility argument. I mean, ultimately, clearly the internet has changed the nature of the media, the way in which information is disseminated. Nobody would disagree with that. But I think there's two points that need to be made about the futility argument. The first is that most examples that people give of that are high-profile, atypical cases, like Peter Lewis. Atypical cases make bad law. And the fact that there are a few cases where suppression orders don't work is not a grounds for not having suppression at all. All they do is simply demonstrate there are a few atypical cases where they don't work very well. The second point to make is that unlike the traditional media, in the new media, the internet and other new media, people actually have to search out the information. If you want to find out who the offender is, you have to look for it. Whereas a suppression order that stops the name going in the newspaper or television just stops, or the evidence for that matter, just stops it hitting people in the face whether they want it or not. And I think that is a significant difference.
What about cases where the suppression order perhaps unfairly casts suspicion on people who aren't involved? I think we saw that with the so-called celebrity drug case, which my mum knew about by the end of the day. There was weeks' worth of gossip around that, and people who were not involved at all were being gossiped about as if they were part of it. I mean, surely that is one potential hazard, Val.
Well, that is, of course, one of the policy reasons which sits behind the whole concept of open justice and publishing the names of accused people, is to avoid suspicion being cast on others within the community. That, of course, is the starting point, but there may be other values that need to be protected, and hence the granting of the suppression order. And that's something which the judge needs to weigh up when deciding whether this is a case where it's justified to depart from open justice. Is that likely to result in the finger being pointed at other people? The particular problem there, of course, was that it leaked on the internet rather than with the making of the suppression order per se.
Bevan, whether you're a print guy, whether you make of the futility argument in the internet age, are these things that everyone just knows anyway now?
I tend to agree with what you're saying. Most people still get their news through the established media sources, whether it's online or not. And yes, there will always be gossip and tittle-tattle, as there was before the net came along, and there were people around the courts and around the newsrooms who would tell you suppressed information, but you had to go looking for it. And I think it's easier now, of course it is, and curious people will find things out. But largely, a suppression order will still stop it from hitting everyone in the face.
Well, we have to take a break now. We'll be back soon, and we'll look at the case of someone campaigning from behind a name suppression order.